Welcome to Lesson 3.3, all about the justice process and trials. In today's lesson, there are several important pieces of information you need to learn. A little bit about how police interrogate people, and then the process of a trial all the way from arraignment all the way to the jury making its decision. So here's your overview, and remember to take good notes. Now, the last video we looked at when you can be arrested and when you can be searched. In this video, we'll look at what happens after you're arrested. So first thing to know is Miranda versus Arizona from 1966. It's a Supreme Court case where the Supreme Court ruled that if someone is arrested, they have to be informed of their right to counsel, to an attorney, and their right to remain silent before questioning can begin. In another important case called Gideon versus Wainwright, the Supreme Court said that you have the right to an attorney to be provided for you if you can't afford one in any felony case. Now, it doesn't include things like municipal cases, like traffic tickets or any other kind of fines. So you don't have the right to an attorney to be provided for you if you're too poor in those cases. The police also cannot use physical intimidation or psychological intimidation. So they can't threaten you with something like, well, if you stay here at the prison, then bad things will happen. However, they can lie to you. So it's important that if you are ever arrested that you remain silent and you ask for an attorney. And don't think that they can always tell you all the truth. They can lie to you. Now, once you're arrested, you'll be booked, and the police would record your name, your photograph, fingerprints. They'd conduct a full cavity search, collect your DNA, and they would take your property into custody. And within 24 to 48 hours, they would have what's called an initial appearance in court. For a misdemeanor, you would be immediately formally charged. That's called arraignment. Now, if it's a felony, then you would have probably a bail hearing where they decide whether they're going to release you or not. So it's kind of, this is where it splits off between a felony and a misdemeanor. And the difference is really how long you might have to spend in prison. Usually felonies are anything where you have to spend more than a year in prison, and misdemeanors are less than a year in prison. So if you're accused of a felony, that initial appearance, you would likely have a bail hearing. And sometimes if you're accused of a misdemeanor, you would also have some kind of a bail hearing at this point. Usually there's a bail schedule in which you would basically pay a set amount in order to be released from jail before your trial. Judges can obviously deny bail if you have a pretty severe crime that you're accused of or if you pose a flight risk. And normally the way it works is that you would post 10% of that set amount that's listed, and then a bond company of some kind would pay the rest, and you would pay them a little bit of a fee for that benefit. The judge can actually release you if you're pretty recognizable, and that's sometimes a point of contention. Now, for felonies, you're also entitled to what's known as a grand jury, which is essentially a process designed to prevent abuse by a prosecutor. You can waive your right to a grand jury and have a preliminary hearing in open court, but either way, they're both designed to determine whether there's enough charges to bring you to trial for a felony. Now, you wouldn't get a grand jury in the case of a misdemeanor, so that would be skipped. This whole process, a preliminary hearing and a grand jury, would be skipped for a misdemeanor. But the whole point of it is an extra step. You don't want to drag somebody through the mud of a murder trial if there's not enough evidence to even bring them to trial. So it's kind of a preliminary step for felonies. So if the grand jury finds that there's enough evidence to bring you to trial, you would have what's called a felony arraignment. In a misdemeanor, you would have your arraignment at your initial appearance. But this is essentially that formal charging. So it's going to occur one way or the other, it's just when it occurs. And at this point, you would actually enter your plea. You would say not guilty or potentially no contest, which is kind of like saying I'm guilty but I don't want to admit to it. You would have any pretrial motions about admitting certain kinds of evidence or saying that my confession was forced and you shouldn't let it in. But plea bargaining would also occur throughout this entire process. So your lawyer might say, okay, you're going to plead not guilty, but throughout the process you're trying to negotiate a deal. And keep in mind that the vast majority of cases do end in some kind of a plea bargain, which is a reduced sentence in exchange for a guilty plea so that you don't have to go through the process of a trial. So if you did end up going to trial, you would have the choice between a bench trial, which is involving a judge making the decision, or you would have a jury trial. The prosecution would present their case first, followed by a defense case, and then obviously the jury can either find you guilty, not guilty. It could end in a plea bargain. They could find you not guilty through a process called jury nullification, which basically means the jury disagrees with the entire premise of the law, but they do know that you committed the crime, but they just say, we just don't think that you should have been charged with this entire thing. Could end with a mistrial, which is another way of basically saying that something got messed up, and so they would try over again, potentially, if they need to. They would run an entirely new trial. And keep in mind that if it's a not guilty or a guilty verdict in a jury trial, those can actually be set aside by a judge if there was just a preponderance of evidence that you actually did or did not commit the crime. So how would you explain jury nullification?
Aren't you recording this?
No, this is the other part. You would say what?
The way, I forget how you put it.
But go ahead.
The way I always explained jury nullification was the jury basically says, yes, we know Dave Aiello committed the crime.
Yeah. Well, they don't say that, like, because they don't care. You just say you're not guilty.
We disagree that this law should have ever even either existed or
Correct.
been applied in this case.
But there's not like a public declaration of that happening. No one ever knows that there was real jury nullification. They can just assume that it happened.
Fair. Okay.
Unless like the jury members come out and be like, "You're not guilty," and then afterwards they do a press conference and they're like, "Yeah, we think that he shouldn't have even been charged."
Yeah. Okay.
Like they know the person did it.
I'm
They
good
just
with
don't-
that.
Yeah.
No, you're not wrong. I was just saying. Okay.
Well, neither are you wrong.
What?
We're neither wrong.
Neither of us are wrong. We're arguing for the sake of we're two debate coaches that just.